Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of vandalism while being a minor. Let's see here. My 16-year-old son is accused of breaking the glass windows of a store. At the time, he was under the influence of drugs. Okay, well, I'm assuming that he was just breaking the glass windows, but not necessarily breaking them to go into the store. Because if he was breaking the glass for the purposes of going into the store, well, then he would be charged with burglary under Penal Code Section 459, which carries up to 6 years. Now, because he is a minor, he wouldn't actually go to prison for these offenses. His case would be handled with the juvenile corrections system. Anyway, your minor still is facing potential felony charges if the damages are more than $950 under Penal Code Section 594. Under Penal Code Section 594, if you vandalize more than if you cause more than $950 worth of damage, that's going to be a felony that carries up to 3 years. If the damages are less than $950, it'd be a misdemeanor under the same code, Penal Code Section 594, which carries up to 1 year in county. However, in this case, it would be in a juvenile detention facility. Now, I understand that your minor was under the influence. Well, first of all, he could theoretically be charged with a violation of Health and Safety Code 11550, which is being under the influence of a controlled substance, which is a misdemeanor that carries up to 6 months in the county jail. But please keep in mind that voluntary intoxication is not a defense. Voluntary intoxication is not a defense. However, if somebody were to have kidnapped your son and pumped him full of drugs and then let him out, well then yeah, if he accidentally breaks a few windows, that's going to be a defense. But if he gets himself high, gets himself coked up or heroin or whatever, and breaks some windows, he's not going to be able to say later on, well, I was under the influence of coke or heroin and that's why I broke the windows, it's not my fault. No. Remember, voluntary intoxication is not a defense. Now, fortunately, it seems to me that this is going to be primarily a restitution issue. It doesn't seem like he actually physically hurt somebody, so more likely a deal will be able to get cut with the DA's office to where if you compensate the victim in this case, sometimes your son may be able to get a deferred entry of judgment to where if he comes back and shows progress and shows that he is not a danger to the community, the judge may consider that to actually dismiss his case down the line. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who ran over a person while being drunk and left the scene. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.